Good afternoon. My name is Shayna Finkelstein, and I'm an attorney with Coast to Coast Legal Aid of South Florida's Family Law Victims of Crime Unit. Today, we're here for this week's legal learning presentation. October is Domestic Violence Awareness Month, so today's legal learning presentation will focus on injunctions for protection. Before we get started, this information presented is not intended to be legal advice, but is for general informational purposes only. A question many people might have is, what can victims do to try to stay safe during these times? If someone is in immediate danger, the first thing they should do is call 911. But it's also important that victims develop a safety plan, especially if they may be quarantined and stuck at home with their abuser. For assistance with safety planning, victims may contact Women in Distress at 954-761-1133, or if there's a criminal case against their abuser, victims may contact their law enforcement-based victim advocate, and they can check with their local department for that phone number, or their victim advocate with the state attorney's office at 954-765-4133. Filing a petition for injunction for protection or a restraining order and contacting Coast to Coast Legal Aid of South Florida for representation on that injunction should be part of their safety plan. So how to petition for an injunction? There are two locations available. There is the Central Courthouse, which is in downtown Fort Lauderdale at 201 Southeast 6th Street on the second floor in room 2140. This place is available for filing between Monday and Friday between 8:30 a.m. and 5 p.m. and they are closed on Saturday and Sunday. There's also the West Regional Courthouse, which is at 100 North Pine Island Road in room 180. This location is available for filing from Monday to Friday from 8 a.m. to 2 p.m. And again, Saturdays and Sundays, they are closed. If you're seeking to file a petition after hours or on the weekend, you should call Women in Distress of Broward County's crisis line at 954-761-1133 to determine if you're eligible to file outside of the court's regular business hours. You should check the 17th Judicial Circuit Court's website for further information about courthouse closures and any requirements because of COVID. And the court's emergency information telephone number is 954-831-7777. You can also check the Clerk of Court website at www.browardclerk.org. You can also find the forms available online at the Florida Courts, flcourts.org, and at browardclerk.org divisions domestic violence forms. There is no cost associated with the forms or filing, and it is a pro se process, meaning that you can do this without assistance from an attorney. However, Coast to Coast Legal Aid of South Florida may be able to provide you with advice before you go and file, or we may be able to assist with helping you to electronically file. Now, when you file a petition, it is a verified affidavit, which means you must swear and affirm that everything contained in the petition is true and sign it. And if your contact information, your address, telephone number, email address is confidential, be sure to let the court know when you are filing your petition. And when you file a petition for an injunction, that makes you the petitioner. And that makes the opposing party, the person who you want the injunction to be entered against, the respondent. There are multiple types of injunctions for protection, and which one you should file for depends on how you are related to the abuser and the abuse that they are committing. Now, if you are related to the abuser because they are your spouse, ex-spouse, related by blood or marriage, living with you currently or have lived with you in the past as if a family, or if you have a child in common, then most likely the injunction that's appropriate for you is a domestic violence injunction. In order to get a temporary injunction for protection against domestic violence, you must show that you are the recent victim of domestic violence or that you are in imminent danger of becoming the victim of domestic violence. Domestic violence being assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any other offense resulting in physical injury or death of one family or household member by another family or household member. This is the only injunction where you do not have to prove that an act of violence has already occurred. it can be enough to show that you have reasonable cause to believe you're in imminent danger of becoming the victim of domestic violence. This being because the parties most likely are living together or have reasons to interact with each other often, that the chance for an incident to occur is higher. Now, other injunctions that may be available to you if your abuser is your intimate partner, but you've never lived together, then there's an injunction of protection against dating violence. Now, the parties must have dated within the past 6 months, and they had to have been intimate, whatever that means for those parties, and involved with each other on a continuous basis. There's also the injunction of protection against sexual violence. This is the only injunction that requires that you have reported the sexual violence to law enforcement and are cooperating with it. And then there's also OBO petitions, which means on behalf of, which are on behalf of minor children, where a parent may file an injunction on behalf of their child if they are suffering from any of these types of abuses. There's also injunctions that are appropriate when the abuser is not your family member or your intimate partner. And these are the types of injunctions that may be appropriate in that situation. The first one we're talking about is stalking. Now, this injunction can be very difficult to prove because of the definition of stalking has several elements, which is a course of conduct directed at a person with no legitimate purpose other than to harass or annoy the other person, and which harassment is likely to cause and which does cause substantial emotional distress. The hardest part about proving this type of injunction is showing that the harassment has no legitimate purpose. So I've seen situations where one party owes the other party money, and so that has been found to be a legitimate purpose for the harassment. There's also an injunction against repeat violence. By the name, it obviously shows that there must be multiple incidents, so at least 2. And this would be the type of injunction if the abuser is your neighbor, your coworker, your friend, a caretaker, someone you know, but you've never lived with together as if a family. And at least one of these incidents has to have occurred within the past 6 months. There's also a sexual violence injunction, which that may be appropriate because maybe you aren't intimately involved with that person, or maybe you're not, depending on the situation. And so that injunction is also available to you, even if you are not in a relationship with them. And again, there's also on behalf of petitions on behalf of minor children, which may be appropriate if your child is suffering from abuse at the hands of, as we said, a neighbor, a friend, someone else in the community. It may be appropriate. So when you petition for an injunction, the process is ex parte, which means that a judge is going to review the petition without hearing from the other side in order to make a decision about whether or not to issue a temporary injunction or to set a hearing or to deny the petition. So here we're going over what the different outcomes might be. The first option is that it could be denied. If it's denied, that means that there's absolutely no protection. What you can do if it's denied is you can file a supplemental affidavit where you allege additional incidents, maybe that have happened in the past, if you only mentioned something that recently occurred, or if maybe other incidents have occurred that you left out. And it's possible after filing a supplemental affidavit that the court will then decide to issue a temporary injunction. You also may receive an order setting a hearing on the petition without the issuance of a temporary injunction. This again does not provide you with any protection, but it does provide you with a hearing date wherein you will have the chance to present your case as to why an injunction should be issued. And again, if you receive an order setting, you have the opportunity to file a supplemental affidavit so that a temporary injunction can be issued. And you will have the option before the order setting goes out to the respondent. You can choose to withdraw your petition so that you're able to allege additional incidents to hopefully obtain that temporary injunction before it is sent out to the respondent. And the final option, which is the option what you are seeking, is a temporary injunction for protection, which will be issued if the petition alleges sufficient facts of violence or stalking. And if this happens, you will get a return hearing within 15 days. A packet will automatically go out to the Broward Sheriff's Office for service, and in that packet contains the temporary injunction for protection, as well as the notice of hearing and the petition for injunction for protection, which includes the allegations. And if there are children involved or a child involved, then there will also be a financial affidavit and a Uniform Child Custody Jurisdiction and Enforcement Act affidavit that is going to be included with the packet. Now, under a temporary injunction, the protections that are available under all of the temporary injunctions, which could be provided to you if you are given one, is that all violence in contact is prohibited, direct or indirect. So this includes third-party contact. So you can't tell a friend to tell them something. That the respondent can't go within 500 feet of petitioner's residence, workplace, or any place where petitioner or minor children go often, like the children's school or daycare. That they're prohibited from possessing firearms, ammunition, or concealed weapons permits. Now, at the time of filing a petition for an injunction for domestic violence, there are additional requests the petitioner could make that provide additional protections, such as requesting exclusive temporary use possession of the home, to request that they be awarded on a temporary basis 100% of the time sharing with the minor children, or to ask for temporary support, alimony or child support, which is up to the judge's discretion based on the petitioner and the children's need and the respondent's ability to pay. So as we stated, if a temporary injunction is issued, it will be sent out for service through the Broward Sheriff's Office, and it will contain the documents that we discussed. They are supposed to try to serve it on them as soon as possible on any day of the week and at any time of the day or night, and that they are supposed to try to serve them. Now, the information they will use to try to serve them will be what the petitioner puts in the respondent description information in terms of their home address or their work address or some type of information for them to be able to find them. When an injunction is issued, if the petitioner requests the assistance of a law enforcement agency, the law enforcement agency can accompany the petitioner and assist in placing them in possession of the dwelling or residence, or otherwise help in the execution of the service of the injunction. And as we state here in large letters, it must be served upon the respondent by a law enforcement officer. It's not enough for it to be a process server or for the respondent to otherwise know about the injunction. It must be served by a law enforcement officer in order for them to be provided with the sufficient notice of when the hearing is and what it is they'll be accused of and what it is that they are prohibited from doing. So as we started to say, that the information they're going to use to serve the respondent is based on what you put in the description information sheet. So what if you don't know their phone number, email address, or other contact information? Well, if you don't have any information to provide them, then most likely the respondent is not going to get served because they don't know where to find them. If the respondent isn't served, then you are able to ask the judge to extend the temporary injunction and reset for another date in order to continue to attempt service on the respondent. And the courts can extend your injunction for up to 120 days for this purpose. At that point, if the respondent is still not served, then the courts will dismiss your injunction without prejudice, meaning that you can refile for an injunction if you later find out where they are located and are able to serve them. So what happens if you're the petitioner and you do not or you cannot attend the final hearing through Zoom? So it is going to be your responsibility to make sure that the court is aware of your contact information so that they know how to contact you at the time of the hearing, but let them know that your information is confidential if it is confidential, okay? You should log on to Zoom at least 15 minutes before your hearing, and you should find out whether or not it is going to be in person or on Zoom. And the judges have included their Zoom courtroom link in their procedures, which you can find at 17thflcourts.org/judiciary list and category. So here are some helpful Zoom tips. You're going to need to use your camera on your electronic device because the judge is going to need to be able to see you to administer the oath and to make a determination about whether or not you are telling the truth. You should practice connecting to Zoom in advance. The most common issue that I've seen is that people don't know how to connect to their audio. And this can cause a lot of delay in court trying to educate people how to do that. So make sure that you select connect computer audio, or if you're using a cell phone, you're going to have to select Wi-Fi or cellular data to connect to audio. Make sure that if you need assistance, have a friend or family member or your victim advocate assist you with connecting to Zoom, but just be sure that if they do that, that once the hearing starts, that you're not talking with them, they're not showing up in the background, because you want it to be as though you are sitting in the courtroom giving testimony. If you have minor children in your home, you should go into a separate room so that they can't hear what's going on and so that they're not making noise that makes it difficult for the court to hear what you're saying. Make sure that you dress appropriately for court, and to use your full name as it appears in your legal documents when you sign in, so that when the court sees you log in, they're not wondering whether or not you're there for that hearing or another hearing, and they are able to speed up the process that way. You may be placed in a waiting room because the judge may be hearing other cases, so please be patient and wait until you are let into the courtroom. You'll be let in when the judge is ready for you. Again, if your location is confidential, make sure there's nothing around you that would identify where you're located. You don't want to be by an open window that shows at the intersection of the streets right behind you, okay? If you get disconnected during the call, log back in or call back in immediately. And if you have trouble reconnecting, contact the court as soon as possible. So when you appear on Zoom, on that day, if you appear, if the respondent is served, the judge will ask you whether or not you are ready to go forward to the hearing that day. Now, it's possible that although you are set for the final hearing that day, it's possible that your injunction will be extended and the hearing will be reset if either party requests a continuance to obtain an attorney or because they want to call witnesses. If for whatever reason your hearing is going to take longer than about 15 minutes that day, the judge will most likely have to special set you on a day where they have more time allotted in order to hear your case. And if there are witnesses or extensive exhibits, that could be a reason why they would need to reset you for another day. Now, as we briefly talked about the types of injunctions there are and the elements for them. And so here we repeat again that at the final hearing, so once what you put in your petition in order to get a temporary injunction, you then at the final hearing have to present evidence to establish that. So for domestic violence, you have to prove the petitioner has been the victim of domestic violence or has reasonable cause to believe he or she are in imminent danger of becoming the victim of domestic violence. For dating violence, you have to prove the petitioner has been the victim of dating violence and has reasonable cause to believe they are in danger of becoming the victim of another act of dating violence. Stalking or cyberstalking, prove that the petitioner has been the victim of stalking/cyberstalking as the definition we went over earlier. Sexual violence, prove petitioner has been the victim of sexual violence. Repeat violence, prove the petitioner has been the victim of at least 2 incidents of repeat violence, one of which has occurred within the past 6 months. After a hearing, the judge will make a decision to either grant the final judgment of injunction protection or deny the entry of a final judgment and dismiss the temporary injunction. Dismissals are without prejudice, like we said before. That means you could refile again if another incident were to occur. The fact that this injunction was denied does not prevent you from filing again in the future. If the judge denies it, they will say that it's denied based on the insufficient facts to allege a case in order for the entry of a final judgment of injunction. If the judge does choose to issue the final judgment of an injunction, they will ask you how long you would like the injunction in place for. If you would like for it to be permanent, you'll say that you want it to be in full force and effect until further order of the court. But the duration of the injunction will ultimately be up to the judge. So while you may ask for it to be permanent, the judge may only grant it for 3 months or 6 months or a few years. And they can make that determination based on how long the parties have known each other, the severity of the incident, whether the parties are likely to run into each other again, whether there's any other pending cases, a variety of factors that the judge can take into consideration. And now if the judge does choose to enter your final judgment of injunction, either by agreement because the opposing party says, I agree to the entry of the injunction and I don't want to have a hearing, so that there's no findings as to whether or not the domestic violence occurred, but that the injunction is still available for protection. Or it's after an evidentiary hearing where the judge determines that based on the evidence presented that they believe the petitioners alleged sufficient facts in order for the entry of a final judgment of injunction. And under a final judgment of injunction, all violence in contact is prohibited, direct or indirect. Respondent can't go within 500 feet of petitioner's residence, workplace, or place where petitioner or minor children go often. No firearms, ammunition, or concealed weapons permits. often temporary and exclusive use and possession of the home in a DV injunction, a temporary time sharing plan, temporary child support and alimony if requested. And potential things that could be ordered against the respondent are that they partake in a certified batterers intervention program, which is a 26-week course, or substance abuse evaluation and treatment, or mental health evaluation and treatment. These are things that the petitioner can request that the judge order against the respondent, or that the judge may on their own decide to order against the respondent based upon the facts that were presented. And this final judgment of injunction is enforceable by arrests, by reporting violations to the clerk of court and or the state attorney's office. So if the respondent is violating the injunction, you can call 911 to report the violation. And if the police do not choose to make an arrest, you can also file an affidavit of violation, which will get forwarded to the state attorney's office, who will make a determination about whether or not they want to proceed with criminal charges. Even if the state does not choose to proceed with criminal charges, you can still proceed on the violation of the injunction in civil court in the injunction case for the judge to make a determination about how to respond to those violations. And now for our contact information, for more information or to apply online, please visit our website at www.coasttocoastlegalaid.org or call 954-736-2400. Please go to our Facebook page and join our Facebook page and and go to our Instagram page. And please be sure to tune in for legal learning next month and every month. We thank you so much for stopping by today to hear our presentation. And again, please log back in onto our Facebook page for future presentations. Thank you so much. Have a nice day.